If you're the owner of a construction project and you are thinking about hiring the lead design professional, likely an architect, with the B101-2017 owner architect agreement, I think that you're on the right path. I think that you could be making a very smart decision. The B101-2017 is absolutely one of my favorite owner architect agreements, with certain notable exceptions where the basic document written by the AIA requires some supplementation to protect the owner. I think it's quite a fair document, and one that I encourage my clients to use, whether they're large companies that build their corporate campuses, or whether these are real estate developers that are doing high-rise buildings or what have you. The AIA B101 2017 is a fantastic owner architect agreement. I'm going to take the second half of this video to talk specifically about its 13 articles and what a project owner might want to consider when they are customizing those 13 articles to swing the B101 into territory that is a little bit more friendly for the owner. But I think probably the first point that I want to make about this flagship AIA owner architect agreement is that it is intended for owners who are looking for a certain measure of protection from the architect against things that are likely to happen in the construction phase. There are other forms of project delivery where the obligation of the architect to protect the owner in the construction phase are less explicit than with respect to this method of project delivery and this particular document. The B101-2017 is intended for projects where you, the owner, is going to have one contract over here with the architect. That's what we're talking about today. The B101-2017 is an example of many documents that could sit in this spot. This is the owner architect agreement. And then you're going to have a separate contract with your constructor, whether it's a construction manager or a general contractor. And when you have these two separate contracts with the different parties, we don't say it explicitly that often, but what has been set up is an intentionally adversarial relationship between the design and construction team, where they sort of like keep an eye on what the other is doing for the benefit of the owner. So if you are a project owner who is only an occasional or perhaps unsophisticated consumer of design and construction services, working out your contracts in such a way that you would have two different agreements, one with the architect over here and one with the contractor over there, that is a great idea, because you will get the benefit of the architect's eyes and ears, in particular during the construction phase, on the construction that is happening on site. And this can provide a really substantial measure of protection for you as a project owner. Heck, even if you're a seasoned real estate developer that's doing a half dozen projects a year, I still think that there is tremendous virtue in having the architect's eyes and ears on the contractor to benefit you, the project owner. The B101-2017 owner architect agreement is not the only AIA contract that you can choose from to have that protection. There are some AIA owner architect agreements that are more elaborate than the B101. There are also a few that are less substantial than the B101 that require a little bit of a higher burden on you as a project owner to sort of fill in substantial blanks that are intentionally left in those documents, because they're intended to be easy for you to customize and get exactly what you want. But in the middle here is the B101-2017. To me, it's sort of the Goldilocks owner architect agreement that the AIA writes. It's not as complicated as a few others. It's not as simple as a few others. But if you want that traditional relationship where you got two contracts, one with the construction team, one with the design team, and you want the architect to look after you, the B101-2017 is really a flagship document that you should think about using. It's good for commercial projects. It can be good for substantial residential projects. I'm working on a couple of single-family homes right now. They're going to be north of $20 million. Certainly that is a lot like a commercial project, even though technically it's a residential project. So when you tend to get into the more complicated residential projects, you can use the B101 2017 as well. It can be used on public projects, it can be used on private projects. And so I would encourage you to take a look at the B101 2017 if you're a project owner. Typically, the B101 is going to be what you would sign first, right? Because when we have this tripartite relationship between the three major stakeholders, we've got you and the architect and the constructor, and you've got separate contracts with the GC and with the architect. That is a situation where you're typically going to sign the owner-architect agreement first, and then you are going to have the design advance to the point that the contractor or the construction manager, whoever's going to be the prime constructor for you, is able to look at the documents that the design team has prepared and be willing to give you a price or a schedule. So if you're wrestling between project delivery methods and you're interested in speed of delivery, I don't know that like this is exactly the right method of project delivery and the right contract for you. There are certainly ways that you could use the B101 and still kind of fast track the project. That would require some custom edits, but a lot of times if you want the design and the construction to proceed simultaneously and to overlap to some extent, other methods of project delivery like design build, where you've got one contract with one party that's responsible for both design and construction, may be a better choice for you. Here, if you're not in a huge hurry, if you have the ability to let the design and the construction progress sequentially so that the architect is hired first. Say you sign the B101 2017 with the architect, the design progresses, and then you take the design out to bid, whether it's public bidding or whether it's a private bid arrangement where you're entertaining a few different GCs that are competing against each other, or whether you're going to just take the drawings and negotiate with one particular constructor that you've selected. The B101 2017 is a great document that gets signed first. The design gets completed. It assumes that the first thing that you're going to do is work with the architect to align your target budget, how much you want to spend, with some understanding around the program. In other words, like what it is that will be included in your project. And there are a number of different design phases set out in the B101 2017 with checks and balances along the way to make sure that the design is progressing in the direction that you're interested in, and that there are cost exercises to make sure that the design is got some alignment with your target budget. The first design phase, SD or schematic design, is typically followed by DD or design development, and then you're going to have the design professional team issue the set of permit documents or issue for construction documents, whatever terminology is used in the local jurisdiction where you're working. And then this document, the B101, envisions a very substantial role for the architect to protect you in the construction phase by providing construction administration services. Certainly, this is something that you can customize if that's not exactly right for you as the project owner. If this is a 100-story skyscraper before you ever get to schematic design, there could be a very fulsome concept design phase, which comes before SD. Or if it's a project where you don't think it's important to have a lot of involvement of the architect in the construction phase, you could modify the scope of the architect services to say that as soon as they stamp their documents and the construction permit is issued, then they're not going to be involved anymore unless you reach out to them and ask them to provide some additional services. So you have this sort of give and take between you and the design team through these different phases to make sure that you're getting what you want and aligning with your budget. And I think that the B101 2017, there are definitely some places where there's some notable omissions, I think, in the standard text, where a well-advised owner would be customizing the contract to address some issues that the standard AIA text of the B101 2017 doesn't address or maybe addresses a little bit lighter than a well-advised owner might wish. But generally, I think that the B101 is great. It's logical for owners and architects. You've got this give and take. There's a lot of flexibility. For example, you can compensate the architect in a variety of different ways. You could pay them on an hourly basis. You could agree to a stipulated sum or a fixed fee, or you could pay them a percentage of the construction costs. The latter being the most complicated form of compensating the architect, and one that tends to breed disputes a little bit more than hourly billing or just stipulated sum. But there's a lot of flexibility here for you as the owner to customize the scope of services that the architect's going to provide, to try to have some checks so that you're getting a design that's not just what you need, but is aligned with your budget. You could pay the architects a variety of different ways. And so, I'll give you an example. There is an idea baked into the B101-2017 that I like a lot, where there's a pricing exercise that is going to happen at the end of each design phase. So after, SD is completed, schematic design, the B101 envisions that there will be a construction estimate obtained. And obviously, when you're at the end of schematic design, the design is way too general for you to get anything like a detailed construction estimate takeoff. But certainly there's room to use conceptual estimating techniques like cost per square foot, or other things like that, where you can find out whether the design is trending to have alignment with your target budget, which, it's possible that between the time that you set your initial budget, maybe there are tariffs and commodity prices have gone through the roof, or maybe there's a new, project labor agreement that is going to govern and is going to change, the prevailing wages that have to be paid to the laborers. And, these things might drive your costs up, even though the architect has done a good job designing the project in line with what you're asking for. Even if there was no scope creep where you decided that you want to add a bunch of new stuff in. So you can get to the end of SD, and even if the architect hasn't done anything wrong, you might do a pricing exercise and realize that, for other reasons, the cost of this building is likely to be different in terms of the assumptions that feed that cost than what we thought when we signed the contract and we set out the initial budget. And so because you have this costing exercise at the end of SD and DD and CDs, you've got the ability at various points along the way, almost like circuit breakers, to say, okay, as the owner, for whatever reason, maybe the scope of the work increased, the project got nicer, maybe there's tariffs, whatever it is, you can say, I'm okay with authorizing additional budget for the cost of construction. Don't diminish the quality of the design. Don't delete anything, architect. I'll just pay more. Or you could say, hey, architect, it's the end of design development. It looks like this project is going to cost 20% more than I got. Time for us to do a little bit of value engineering. And so this is a nice thing to have at the different phases at the end of SD and DD and CDs, because when you get to the end of the procurement phase, whether you're doing public bidding and you're trying to elicit the lowest responsible bid, or whether you're doing private bidding where you've just maybe thrown it open to 2 or 3 contractors to compete against each other for pricing, or whether you're negotiating with one particular contractor that maybe has been helping you with pre-construction services as the design evolves, whatever the case may be, however you're getting to the number with your constructor that they want to be paid, when you get to that number, the B101 envisions, if that number is higher than what you want to pay, if you decide to not increase your budget, there's a variety of options for you and the architect to try to get on the same page and for you to have your budgetary goals met. One of them, if you elect to not increase your budget, is value engineering or modification of the design at no additional cost. So the architect will take your direction to, reduce the price of the project by 15% by diminishing its scope or its quality, if that's the choice that you make, if you choose that in lieu of increasing your budget. The basic understanding in the B101 is that this would be done at no additional, cost. So you would not owe the architect more fees. This is kind of fair to the architect because if you're following the agreement and there's a pricing exercise at the end of SD and DD and CDs, you really should be tracking pretty close to what you want to spend. And so it shouldn't be a huge lift for the architect to do a little bit of value engineering after we have a contractor in the picture in order to tweak the issue for construction documents into a version 2.0 that the contractor is going to be willing to build at a price that's within your budget. There is some language in the B101 around that sort of value engineering exercise that the architect would have to undertake if the costs are coming in too high at the very end, like after the construction documents were issued, that you might want to think about. There's some room for some custom edits to better protect the owner. But I'm going to get into a lot of those specific edits when we get to the second half of this video. The B101, as I mentioned, assumes that the architect is going to do a lot to protect you in the construction administration phase. And we all know that there are going to be submittals, shop drawings, things that are going to be generated by the construction team, go to the architect. They're going to review these documents and make sure that the way that the contractor is going to implement what is designed in the issue for construction documents from the design team, the specific boiler that they're going to install, the elevators, the glazing, all of the things that they intend to put in, it gets submitted to the architect. The architect looks at it. They say, this is or is not consistent with my design intent. So we've got this submittal process of shop drawings and samples and mock-ups. And so that is a way that the architect, protects you in the construction phase. But also the B101-2017 assumes that the architect is going to come to the site from time to time and evaluate the construction work that's in progress. And I think that the B101 does a good job, along with a companion document, the A201 General Conditions, which I'll talk about in a second, of setting proper expectations. The architect is not going to be there every single day during construction. They're not going to watch every nail being driven. They might come once a month. So it's necessarily the case that the construction is going to advance when they're not there. Walls are going to be sealed up. So it's not appropriate to think about the architect as the guarantor of perfect construction, even though they're going to come to the site from time to time and observe the construction, because they're not going to be there every day unless you want to pay them to be there every day, which is probably going to be prohibitively expensive and something that almost every owner is going to decide they don't want to do. The B101, along with its companion document, the A201-2017 General Conditions, does a good job of including language in there that requires the architect to come from time to time and to keep their eyes on the construction and make sure that the final construction is going to be consistent with their design intent to the extent that they can see it when they're on site. It's fair about certain things being the responsibility of the contractor. The way that the contractor executes the construction, the means and the methods of construction and safety precautions, those are on the contractor. And we've got this sort of fair allocation of responsibility between, what the contractor is going to do, what the architect's going to do, the way that it's going to be almost intentionally adversarial between them a little bit to kind of protect you. And so I really do like the way that the B101, takes on the role of the architect to protect the owner in the construction phase. And there's a lot of other stuff that the design professional is going to do as well that the architect is going to do. They're going to review the contractor's request for payment. And this is one of the areas that they're going to be able to really help you, because if the contractor says we're 33% complete, you're probably not going to be able to tell whether it's accurate or not, but the architect is going to be able to say, no way. They're going to say, you're not any more than 26% complete. And so, this act of having the architect review and to certify payment applications is important. It's also important to understand that there probably isn't an architect in the universe that's really going to understand what you as the owner of the project ought to be thinking about as you evaluate a contractor's request for payment. Architects don't understand mechanics lane law. They don't understand the proscriptive and the prescriptive requirements of state law in terms of the documents that you as the owner need. They're not going to be able to evaluate the content of those documents. They're also not going to know what your lender requires or what your title insurer requires or the requirements of your construction escrow agreement. And so, there is a role for the architect to protect you. giving a percent complete and walking the site and thumbs upping or thumbs downing the construction that they can observe that hasn't been sealed up. That's not to say that you as the owner don't need to have a construction lawyer minding all these other issues when it comes to payment of the contractor to make sure that you're complying with state law. But we do have this mature agreement, the B101-2017, and its companion, the A201-2017 general conditions, that draws these appropriate lines of demarcation and really creates a fair division of responsibility between you as the owner and the GC and the design professional, and the tension between them, keeping an eye on each other to sort of protect you from problems that may be caused by one that might go unnoticed by you, but that the other would see. I've mentioned a few times now the A201 general conditions document, which is so critically important for you as a project owner that if you don't remember anything else after you leave this video, this is all that I need you to understand, okay? If you're using an AIA contract and you've got that tripartite arrangement with three major project stakeholders, you and the architect and the contractor, and you've got separate contracts. This is you've got an agreement with the architect over here. Let's say it's the B101-2017 here, although it could be a wide variety of other AIA agreements as well that are owner-architect agreements. And then you have a contract with the constructor over here, and there's a wide variety of different contracts that are written by the AIA between you as the owner and the constructor that could sit in that role. When you have this tripartite relationship with separate contractual arrangements with the design team and the construction team, it is almost guaranteed, unless you're using a handful of exception AIA documents, most of the time when you have this different contract arrangement with different agreements between the construction team and the design team, the A201 general conditions is a document that's going to kind of sit inside the triangle here, and it is going to apply. And so if you think that you can sign a B101-2017 without paying attention to the A201 general conditions, which is incorporated by reference into the B101, then you're really doing this. You're really blinding yourself to something that's really important, because the A201-2017 general conditions document, it's 38 pages long and it's chock full of essential terms for you as the project owner. The A201 says the word architect more than 300 times. I think it says the word owner more than 400 times, and it says the word contractor more than 500 times. Crammed into these 38 pages are a lot of concepts about how you and the architect and the contractor are going to play nicely in the sandbox together, largely during the construction phase, right? So your B101-2017 agreement with the architect, it's going to set out the business deal that you have with them. What are they going to do? What building are they going to design, and what fee are they going to get? And then your agreement with the contractor over here is going to say, what's the business deal with the contractor? What's the scope of the work that they're going to provide? How much are you going to pay them? How much time are they going to have to complete? So you got the business deal and the owner-architect agreement and the owner-contractor agreement. But here in the middle, you've got this general conditions document that is going to explain the give and the take and the push and the pull between you and the architect and the contractor, largely in the construction phase as you work together. I can't tell you how important the provisions of the A201 general conditions are. I've got 90-minute videos on my website that talk about this, so I don't want to go too far into them, but I will tell you, for example, that the general conditions, it deals with matters of payment, it deals with matters of insurance, and you simply can't, as a project owner, use a B101-2017 without being cognizant of the A201 general conditions document. When I say it's incorporated by reference, what I mean is that the A201-2017 general conditions document, it doesn't call for a signature, okay? That's different than the B101-2017, the owner-architect agreement. The owner-architect agreement is going to be signed. But the general conditions document is merely assumed to be a part of the B101-2017, It is incorporated by reference. It doesn't call for a signature. And even if you are entirely unaware as a project owner that the A201 is out there, even if you've never seen it, you've never negotiated it with the architect, it is 100% a part of your agreement with the architect if you're using a B101 or, most of the AIA agreements that have this tripartite kind of triangle arrangement. And the general conditions is going to be equally a part of your owner-contractor agreement when you eventually select the contractor, even if you don't have one that you look at, even if you're unaware that it's out there, it is incorporated by reference, no signature required. And so what it means is that the off-the-shelf standard text of the A201-2017 general conditions is going to apply. It's going to be part of the owner-architect agreement. It's going to apply and be part of the owner-contractor agreement. So you have to get your hands on one of these, and you have to engage with what it says, because it is absolutely an essential part of your arrangement with the architect and the contractor when you are all going to be working together. One example is that few contractors are going to be over the moon with excitement about the idea that the architect is going to be walking around the site and keeping an eye on the quality of construction. Most contractors are not going to be thrilled with the idea that the architect's approval of a request for payment from the contractor is one of the things that triggers your obligation to pay the contractor. The contractor begrudgingly accepts this arrangement because the A201 has got some checks on the authority of the architect to reject a request for payment and to reject substitutions and things of that nature. And so this A201 general conditions document is sort of a grand compromise between you and the contractor and you and the architect, and how you're all going to kind of come together in the construction phase and have win-win outcomes. So please make sure that you're paying a lot of attention to the A201 general conditions document. It's not a document that you're typically going to negotiate the terms of with the architect, because in this sequential method of project delivery where your constructor might not come on or be identified until a year after you first hire the architect to begin to produce their design, it would be incongruous for you and the architect to go and negotiate the general conditions document up and then to stick the GC with it a year later when they come on the scene. So typically, when you're negotiating a B101-2017, when I say that you need to be cognizant of the fact that the general conditions document is out there, that is not to say that it is traditional for you as the owner to negotiate the terms of the A201-2017 general conditions document with the architect. When you negotiate the B101, you need to know that it's out there. You need to know that it has certain obligations, that are assumed to be your responsibility and the architect's responsibility. And in the event that it turns out that some of the things that the A201 general conditions assumes that you as the owner are going to do, if you're not going to do some of those things, you can note that in the B101-2017 owner-architect agreement. It says that, hey, architect, for purposes of what is going to happen in the construction phase, the owner and the architect are going to agree that, these assumptions are not going to apply. We would write that in the B101-2017, not necessarily in the A201-2017, because you don't want to have that document negotiated before there's a contractor on the scene. And then when you as the owner have already signed the B101 with the architect and they've produced the design and you've selected a contractor and you're negotiating the owner-contractor agreement, right, this leg of the stool, that is typically where the A201 general conditions document is going to get negotiated. And it's where, if there are some assumptions that you made about certain aspects of it not applying in the B101, you can then reflect that in edits to the A201 general conditions when you got your GC on board. And when you are negotiating possibly the terms of the A201 general conditions document when the contractor is on board, you also have to understand that those custom edits are not going to bind the architect unless it agrees to those edits. So first you negotiate the B101, you sign it with the architect, they produce their design, you go and you find a contractor, you're negotiating a construction agreement, and that is a time when possibly the A201 general conditions is going to get negotiated between you and the contractor, and that is going to require the blessing of the architect. If they don't give it, they're not stuck with your custom edits. They merely have to do whatever the off-the-shelf version of the A201 general conditions produced by the AIA assumes the architect is going to do. And certainly you don't want to have the architect and the contractor singing off of two different sheets of music here. So there's definitely like a coordination between the different agreements when you pull this all together. I'll also mention a very important concept that a lot of project owners struggle with, and I think it's essential for you to understand if you want to be protected in a dispute. Let me just start by saying that I represent tons of project owners. I represent institutional property owners, people that own malls and hospitals and power plants, and I represent large companies that are building corporate campuses, and I represent real estate developers that are doing skyscrapers and strip malls and whatever you can think of. Okay, so I represent a lot of owners, and when I'm not representing the owner, if I happen to be in the negotiation on the side of the architect, I'm pushing for things to preserve the viability of the architect's professional liability insurance that are important for the architect, that are just as important for the project owner. So it doesn't matter whether I'm representing you as the owner, which I do all the time. I want the same things when it comes to certain aspects of insurability under the architect's professional liability insurance as I do when I represent the architect. Because what a lot of project owners don't understand is that you could put custom language into the B101-2017 or really any agreement with a design professional, whether it is another AIA document or a non-AIA contract or an agreement between you and an engineer. If you stick certain words into the agreement with your design professional that are the kind that take them outside of the coverage of their professional liability policy, you can destroy the insurance coverage that you as the project owner so badly need in the event that there is actually a design mistake. So I'm going to take a step back here and try to unpack this a little bit because it is so important to understand, and it is something that I spend a lot of time when I'm representing architects trying to educate owners about, especially when they're not represented by a construction attorney like myself. A lot of times, real estate developers and project owners are going to be represented by their real estate attorney. And real estate attorneys, while they have a huge skill set that I do not have because I don't do real estate, they lack some of the knowledge that a real design and construction attorney brings to bear. And so I will often get into a negotiation for a B101-2017. I'm representing the architect. I get an owner, and the owner is represented by their real estate attorney or by some in-house attorney, and they very clumsily start to foul the document up with all kinds of concepts that would destroy the architect's professional liability insurance coverage. And I have to say to the owner, I'm like, listen, there isn't an architect in the world that has a safe in the back of their office with a bunch of gold bars or $1 million in it. Architects are comparatively they're not well compensated. Their compensation is comparatively low compared to, say, for example, what you're going to pay to a GC. They will not have the money to pay out of pocket to protect you, the owner, in the event that they make a design mistake. The only substantial asset that they bring to the table is going to be their professional liability insurance policy, which exists to protect you, the project owner. In the event they make a mistake, it's the professional liability insurance policy that is going to cut you a check for $1 million in the mediation, or is going to cut you a check after you win the lawsuit. That policy exists to reimburse you in the event that there are design errors. And so when we begin to get into customizing the B101-2017, or really any agreement between you as the owner and any design professional, if you start to stick the wrong words inside there and you destroy the architect's professional liability insurance, at the end of the day, you're the one as the owner that is going to have a bad outcome. And I used to joke to try to drive this point home when I was advocating on behalf of an architect, I'm talking to a real estate attorney who represents the owner on the other side, and I'm saying that, like, okay, if you want to stick all this language in here about guarantees and warranties and about how the architect is going to defend you from claims and they're going to reimburse you for your attorney's fees and, all these things that tend to run afoul of the professional liability insurance policy. Like, if my architect client agrees to this, you'll win the lawsuit, but it'll be a Pyrrhic victory because at the end of the day, you will not get a dime because you can't get, blood from a turnip. And I used to say that if you win the lawsuit, you're not going to get money. What you're going to get is the ability to put the design professional out of business, and you're going to get the ability to take over some cool office space and some used computer equipment. And I've kind of modified that in recent years because one of my favorite architect clients says, no, Jeremy, architects lease their computer equipment. So now I say, hey, owner, if you insist on fouling up this B101-2017 with all this language that is not in your interest, is not in the architect's interest, that is going to destroy the professional liability insurance coverage, after you steamroll them in a lawsuit and you win and they declare bankruptcy, you know what you're going to get? All you're going to get is the right to take over some nice office space, right? Because architects don't even own their own computer equipment. So it is so important for you as a project owner to understand that when it comes to not using terms and words and concepts in your owner architect agreement that's going to destroy their professional liability insurance coverage, that's not just good for them, it's good for you too. And this is something that I imagine I'm going to have the same conversation that I just described with you multiple times a week for the rest of my career, because this is just something that is not intuitively understood by project owners. Make sure that if your architect actually makes a mistake and you want to sue them, when you whip your contract out and you file suit on it, their insurance company doesn't say, sorry, architect, you're on your own, there's no coverage for you. And the off-the-shelf version of the B101 is insurable, but when you start getting tricky with your edits, you can take it outside of the insurability space. And so you really want to make sure that you understand where those boundaries are and that you don't do that. Because you're going to have to customize the B101-2017. It's really just the starting point for negotiations. I mean, it's already a pretty long document, and if you think about how long it gets when you pair it with the 38 pages of essential terms in the A201-2017 general conditions, it's already a pretty long document. And the AIA did not endeavor to write the B101 or really any of its owner architect agreements to be totally comprehensive to handle every risk in every situation. So you are going to need project-specific edits. You're going to need party-specific edits. You're going to need to make sure that the agreement reflects that there may be lender approvals that are required, or certifications to be made by the design team. In the event that there are, if it's a building that's not a ground up project, it's different than if it's a rehabilitation project. What happens when the walls get busted open and you find surprises in there? Like, what are the sorts of things that an architect should have known just from like inspecting the building or understanding the form of construction or maybe looking at the as-built drawings that you gave them? There's so much project specific customization that is going to go into any one of these contracts. You really can't take the B101-2017 off the shelf and just sign it after filling in the blanks, because you're going to be a little bit blind to some of the project specific issues. Another example is what if you're building right up against a property line near another building? Like, there's a lot of stuff that a well-advised owner like yourself is going to want to get into the B101-2017 to deal with some of these project-specific issues. And the very first thing that I do whenever I negotiate a contract, regardless of who I'm representing, is I want to learn all about the project, and I want to go through what I call an issue spotting exercise so I can say, oh, okay, well, this project needs 12 clauses in it that, are unique because of the uniqueness of the project. And when you go and you go put those edits in, you got to make sure you don't destroy the professional liability insurance coverage while you get smart edits in that are intended to kind of swing the the contract, appropriately in your favor. I mean, it's not a zero-sum game where you're looking to cream the architect, but like you could swing the contract to be a little bit more in the favor of, the owner, the one that's taken out the loan, the one that's taken the most risk. I like to say in construction projects, the golden rule applies. Whoever has the gold makes the rules. That's you as the owner. That means that it probably should be a little bit of an owner-sided agreement. And when we begin to swing it a little bit in your favor, still within the bounds of commercial reasonableness, to deal with project-specific edits, when we go beyond the standard language of the B101, we want to make sure that we do it appropriately without destroying insurance. There's party-specific edits. I mean, if you're hiring the engineering team and under separate agreements, and they're not going to be sub-consultants to the architect, that calls for specific language that you want in the B101 about the architect's obligation to coordinate with these designers. If you have a tenant, maybe it's a restaurant or it's a hotel, you've got a work letter, there's some coordination with other design professionals, from your tenant or your lender, or possibly you're hiring an interior designer yourself. You want the architect to coordinate with them. There's party-specific customization that is necessary as well. Maybe the mechanical, electrical, plumbing, and fire protection systems, MEPFP, are going to be engineered by the same design-build subcontractors under the GC that are going to actually build the systems. If that's the case, you're going to need some custom language in the B101-2017 to deal with these party-specific and project-specific nuances that somebody like myself would help you get in there through an issue spotting exercise. You're also going to need to be really careful about state law specific customization. Most states are going to limit how far you can push an indemnity clause. A lot of states are going to have a lot to say about what is the process for approving a contractor's payment request. Sometimes they're automatically approved if you don't act quickly enough. There are proscriptive and prescriptive requirements in most states about what kind of paperwork you need to get and what kind of content within the paperwork that you need to get, sworn statements, lien waivers, things of that nature, before you could pay the contractor without exposing yourself to having to make a double payment if the subcontractors place mechanics liens on the project. These are all the sorts of things that are state law specific edits that could be called for in the B101-2017 or really any of your agreements on the project. So, we've got a good document. It's flexible, it's sensible, but it requires issue spotting. It requires party-specific, project-specific, state law-specific customization. You're gonna want to make those edits without destroying the architect's professional liability insurance. I cannot tell you how important that is and how I'm going to spend the rest of my career when I'm representing owners. Practicing what I preach. When I am negotiating on behalf of the owner in the owner-architect agreement, I do not want to foul up the architect's insurance any more than I want to make sure the insurance doesn't get fouled up when I'm on the other side of the coin and I'm representing the architect. So there's a bunch of stuff to think about. I do want to pivot over to the second half of this discussion now. I want to talk about custom edits that you might think about putting into the B101-2017. The document's broken up into 13 different articles. And what I'm going to talk about here is the tip of the iceberg, right? So if you are taking copious notes on what I'm about to say and you go and you say, I don't need a lawyer like Jeremy because he just gave me the playbook for negotiating all my contracts, you're going to have bad outcomes because you're getting about 1,000th of what I think about here. So what I'm about to tell you is just intended to stimulate thought and help you issue spot and to understand what you're getting into. It's not intended to be legal advice for you, and it is not a substitute for hiring a knowledgeable attorney that can help you navigate some of these edits. Article 1 of the B101 is initial information. Here is where I think that the document could use more language about the architect needing to determine the owner's programmatic needs and goals and objectives and verifying and finalizing the owner's program to make sure that they really understand what you need in terms of your requirements around like spatial and functional issues and adjacency and growth issues and site analysis and phasing and HVAC and power and MEPFP, any sustainable design issues that you have. I mean, there's a bunch of room for us to include language in Article 1 here to try to flesh out the obligation of the architect to really understand what you need, right? So that they can design that and they can make sure that the budget that you're targeting is consistent with what you want. So there's a bunch of custom edits I'll put into Article 1 initial information. Article 2 is all about the architect's responsibilities. Here is where we discuss the idea of the standard of care, right? An architect, like all design professionals, and really like all professionals, are not going to guarantee you an outcome because between every completed design, there's a contractor that can make mistakes that could lead to you as the owner having an unhappy outcome in the end. So architects are not going to guarantee a good outcome for you. They're going to guarantee that they will, well, they're not going to guarantee, they're going to become contractually obligated to abide by the standard of care to do an appropriate job in providing their professional services to you. The standard of care definition is addressed here in Article 2, but there's room for there to be supplemental concepts put in here that, if you're careful, won't wreck the architect's professional liability insurance. I mean, there's nothing that would stop you from expounding upon the idea that, without making guarantees or promises, that the architect needs to provide reasonably accurate and complete construction documents, that they need to provide notification to you in a timely manner of any issues or discrepancies that they become aware of. There's a way for you to kind of bolster the idea of the architect complying with applicable laws, whether they're current or these are laws that are about to be enacted or to go into effect in the short term when the project is being constructed, around a whole bunch of issues. And there's good language in Article 2 about the standard of care, and it's minimally adequate if I'm an owner. I can live with it as it's written. I think the AIA has done a nice job, and I'm not saying that just because I'm a liaison to the AIA contract documents committee and I get to put my 2 cents in on their standard forms every now and again, like a few thousand other people like myself who are liaisons to the contract documents committee. But so I can live with the standard language. But in a perfect world, if I'm representing an owner on a major project, I'm going to want to think about expanding upon the obligation of the architect for compliance with laws around building, health, sanitary, and environmental codes, or building or zoning regulations, surveys, special exceptions, zoning conditions, restrictions, covenants, easements, concepts around accessibility, concepts around construction, use, occupancy, maybe regional climate or other local conditions. Certainly, probably the most dangerous thing out there for people that own commercial property are accessibility issues. The Americans with Disabilities Act, Fair Housing Act, and the state and local codes and regulations that speak to these this obligation to make sure that the building is accessible to disabled persons. There's probably no greater disconnect, in my view, between what an owner of a building's actual risks are for getting stung with a bad outcome in court, and what they understand the risks to be than around accessibility. And so it's certainly not fair to stick the architect with all accessibility responsibilities. And even if you tried to do that in a contract as an owner, a court might strike that down. But if I'm representing an owner, I'm going to wade a little bit into what is the architect's obligations around accessibility in this Article 2 when I'm talking about the architect's responsibilities. I'm interested in knowing if there's disclosure of any financial conditions that might create a conflict of interest for the architect. If they are maybe getting some sort of promotional or quantity discounts or trade commissions or rebates from parties whose products that they specify or they suggest be used. And then, when it comes to Article 2 and really the entire owner-architect agreement, whether it's a B101 or any other, if I'm the owner, I need to talk to my insurance broker. And I need to have the insurance broker's eyes on every inch of the owner architect agreement and the general conditions and the owner contractor agreement. I think it's exceptionally important. It's not just because you're concerned about the insurance that the owner is going to provide and the contractor is going to provide and the architect is going to provide, but there are other ways that your insurance broker is going to be able to help you understand insurance issues that are important to you that go beyond what the typical attorney is going to understand. Being an insurance broker in the state of Illinois, where I'm sitting right now, is a licensed and regulated profession because there's continuing education requirements around what's the market doing, what's commercially available, what endorsements can be purchased, which can't. And this is the kind of thing where I like to partner with your insurance broker if I'm representing you to make sure we get insurance right. And there's an element of this that needs to be addressed when we're looking at Article 2, Architect's Responsibilities. Article 3 talks about the scope of the architect's basic services. It assumes that the architect is going to provide architectural services and structural and mechanical and electrical engineering services. But there's room to go further here because it may be the case that they're providing more services. There may be plumbing engineering or fire protection engineering services or commissioning, code consulting, acoustics, information technology, audiovisual, security, lighting, elevator design. There's so much more that could be added to the B101-2017 to kind of flesh out the scope of the architect's basic services. And here's another spot where you're going to want to really think about coordination, right? If there are design professionals that you're hiring or your tenants are hiring, or maybe the contractor is hiring for design build MEPFP, what is the scope of the architect's basic services around coordinating all this design? I have almost a page of text that I like to insert into the B101 to try to make sure that we get everybody's expectations aligned so there can be win-win outcomes and you could be protected as the owner. There's a bunch more language that could be included in the B101 about the assistance that an architect needs to provide to you as part of its basic services in Article 3 about getting approvals, right? Maybe attending city, county, local, community, and quasi-governmental stakeholder meetings, whether it's utilities or neighborhood groups or civic groups or meetings or hearings related to the project, additional language that could be put into Article 3 to define the architect's basic services around securing your approval as the owner before proceeding from one phase to the next. Maybe the architect needs to make presentations to you as you deem necessary. Maybe you're entitled to illustrative sketches or study materials, or other, graphical materials that are necessary for them to clarify and present their design for you, right? This is language that we could put in to customize the B101-2017 to better protect you. It is possible to include additional information and obligations for the architect to get clear about certain things that are not in Article 3 of the B101 that could be commercially important to you as the owner, around as one of many potential examples of providing and updating measurements as its design progresses about how many gross square feet are going to be in the building, and how are they going to calculate that? And what about gross and rentable net square footage and net usable square footage? And are we how are we getting there? Are we using the applicable ANSI or BOMA standards or other appropriate standards? And are you going to be receiving as the owner graphic illustrations using floor plan sketches and studies to explain how the calculations are put together and how many parking spaces and how are they going to be arranged? I mean, these things go into your commercial assumptions, that you're using to, figure what you're going to be able to sell the building for, what kind of, lease rent you're going to command. And this goes into, can you service your debt, right? And so you shouldn't be sitting there blinded to this stuff as the design is developing, but these are not necessarily concepts that are in the B101-2017, because if they stuck all this stuff in there, it'd be 100 or 200 pages long and it'd be impossible to use, right? So a construction attorney is going to help you get some of this in there. Just as another of 100 examples, does the architect have a responsibility to deliver files and documents to you at certain places, at certain phases? At the end of design development, do you get a copy of their drawings and their specs and their Revit files and their CAD files, or their BIM models, or their BIM model elements, or their calculations, or their other work product? Is it digital or is it paper? Are you getting reproducible copies? Is this something that you get at the end of the project, at the end of the construction documents phase? This is not something that is very well addressed in the B101 2017, just because the AIA is trying to be practical and to not overwhelm people and to make the document 200 pages long. Each one of the design phases, SD schematic design, DD design development, CDs, construction documents, CA construction administration are addressed in detail in Article 3 of the B101 2017, which again talks about the architect's scope of the services. And there are so many additions that I'm going to want to put in for an owner in at the SD part of the contract to flesh out the obligations, and the same in DD and CDs and CA. So, there's a lot that could be added to sort of not make it an unreasonable or unfair document, but to kind of get everybody's eyes on what your expectations as the owner is before the contract is signed, not so we can have claims, but so that we can have everybody singing from the same sheet of music, and we can have predictable win-win outcomes. Good construction for a fair price, good design for a fair price. Project comes in on budget, project comes in on schedule, everyone's happy, no disputes. The way we do this is by being clear in the contract about what everybody's expectations are. And in my humble opinion, it doesn't do you as a project owner a service to be vague about some of this stuff. Let's get it on the table and make sure that the architect sees it and understands it, so we can have those win-win outcomes. As I mentioned, construction administration, the construction phase of the project, is going to be addressed not just in the B101 2017, but very substantially in the A201 general conditions, with its 38 pages of essential terms and its mention of the word contractor more than 500 times, and owner more than 400 times, and architect more than 300 times. I actually think that some form of the word architect or architecture is in the general conditions. I think it's 317 times to be specific. So there's a lot of stuff that you're going to need to look at in the B101 and in the A201 general conditions. About the construction phase, you're going to want to be very careful generally as the owner. And you're going to want to make sure that you include a lot of thoughtful edits just to get everybody on the same sheet of music. But one that is particularly important, one of 1,000 possible edits, I think, is you may want to consider as an architect, when the general conditions has more than 300 references to the architect and ascribes to them a lot of obligations. Do you want your hands to be tied as the owner if you don't like the way that the architect is administering the contract? Or do you want to add some language which allows you the right to perform certain duties of, or to review and possibly veto certain decisions of the architect during the construction administration phase for the good of you and for the good of the project? Of course, not authorizing you to perform professional services, because presumably if you're a real estate developer or project owner, you're not a licensed and registered design professional in the state where the project is. So we can't cross the line into you providing professional services, but certainly there's room to make sure that you've got a little bit of veto power over some of the stuff that the architect is doing. And I've got some important nuance edits that I like to stick in there for my owner clients. In the construction phase part of the contract documents, whether it's a B101 2017 or some other owner-architect agreement and the owner-contractor agreement and the general conditions. Sometimes I'll include a bunch of other requirements, maybe that there be a pre-construction conference, maybe that there be a camera on site that's streaming 24/7 that I can, keep a recording of. Maybe I want a requirement for the architect to attend meetings and to prepare meeting minutes, and there's room in the contract documents to add quite a bit more if you think it's appropriate as the owner for, what precisely is the architect's obligations around evaluating the work and reviewing submittals and pay apps and changes in the work and, certifying project completion, whether it's substantial completion or final completion. There's a lot here that could be added to protect a well-advised owner and to make sure that whatever they expect is written down and put in the face of the architect, not to be unfair, but just so that the architect isn't caught by surprise when the owner's like, why aren't you doing these things that I need? And they're like, well, it's not part of my contract. Article 4 of the B101-2017 talks about supplemental and additional services, which I always find to be a little bit of a confusing concept. Everybody knows what basic services are. Everybody knows what additional services are. But what's this third kind of services? What's this third category of services? Supplemental services. Well, Article 4 is largely about supplemental services. There is a matrix, a little spreadsheet, a chart in Article 4 that talks about supplemental services. And I got to tell you, 99% of the time, owners and architects fill that chart out wrong. They don't understand the AIA's intent. And it can be a little confusing. And the way to think about supplemental services, if you're a project owner, is a lot like the concept of an agreed alternate in a construction contract, right? You might have a half dozen alternates that you haven't included in the scope of the contractor's work, but you may decide in the middle of the project, we are actually going to accept alternates 2, 3, 4, and 7. And it's kind of baked into the contract, like what is the scope of that work and what is the pricing. The idea of supplemental services is kind of similar. It's something that's on the menu. It's something that the architect is willing to provide for you, but maybe isn't part of their basic services, right? And an example might be preparing as-built record documents to reflect, what is the final design and construction of the project. That is something that could be designated in Article 4 as a supplemental service. If it's something that the architect is willing to provide, but it's not part of their basic services, the basic idea in Article 4 is that supplemental services are going to be billed by the architect on an hourly basis to you, the owner, above and beyond their basic services. But you're really going to want to sort of fill out that chart properly. And underneath the chart, there's a fill point or a blank for you to use more words to elaborate upon when we indicated in the chart that the architect is willing, by way of one example, to provide facility support services, right? This chart contains a bunch of possible services the architect might provide along the vertical axis. One of them is facility support services. It might be indicated that the architect is going to provide that as a supplemental service if you ask for it on an hourly basis. But what the heck does that even mean? Facility support services. I have no idea. I negotiate this contract every day. And if you don't move down to the fill point underneath that chart and explain that facility support services above means that the architect is going to X, Y, and Z, there's room for ambiguity. So you got to get the chart right. You got to distinguish between what in the chart is a basic services, what's additional services, what's supplemental services. Are there some things that are not on the menu at all, right? A lot of architects are going to indicate that they will not provide cost estimating services no matter what. Not as a supplemental service, not as an additional service. They will indicate that in the chart in Article 4 if that's their stance. So we got to fill it out right. We have to indicate what's the owner's obligation, what's the architect's obligation, what is not the architect's obligation, what is on the menu for supplemental services, what is not, and then we got to describe underneath in the fill point, for each box we check to indicate in the B101-2017 in this Article 4 in the chart about what they're going to do, add a paragraph for each check mark you put in to make sure that we know specifically what the scope of their work is, if it's supplemental or other. It's a good idea to fill in a lot of the blanks in Article 4. You know, how many submittal reviews are we estimating? How many visits to the site is the architect gonna make as a matter of their basic services for site observations? How many visits to the site are they gonna make around punch listing and substantial and final completion? So there's a bunch of places where you as the owner would be well advised to consider thinking about fleshing out the detail in Article 4. Article 5 is entitled Owner's Responsibilities. There's room for a lot of nuanced edits here to protect you, but basically we need to have your eyes attached to your brain as the project owner reading this thing carefully to make sure that you're not making promises that you can't or don't intend to live up to. Because if an architect is going to get into a dispute with you, they may look at this Article 5 and say, here's all the owner responsibilities that they didn't live up to, and better for you to go and expunge that language from the contract before it's signed than to pay no attention to it and then have the architect make the argument in the future that somehow you fell down in your obligations to provide whatever it is that is promised of the owner in Article 5. Article 6 of the B101-2017 talks about the cost of the work, and you probably know as the project owner that the capital C, capital W cost of work is a term of art. It is exceedingly important for you to pay attention to what is and is not a part of the cost of the work. Less so in the owner-architect agreement and more so in certain owner-contractor agreements, but there's some important language in here as well. And there is a little bit of a limitation of liability for the architect that's kind of baked into Article 6 of the B101-2017. Where I discussed it earlier, if the bids come back too high, the owner decides that they don't want to, increase their budget. Instead, you're going to revise the scope. The architect's going to perform value engineering services at no additional cost for you. There's some language in Article 6 that talks about that being the, quote, limit of the architect's responsibility, which could be a limitation of liability on behalf of the architect. And so if you're an owner where, you're pushing up against, how much money can you borrow? And am I going to be able to pay for this? Yet I'm pushing the architect to design something that's going to butt up against, what I've got. There's room for some thought and attention for a well-advised owner to maybe make some custom edits in Article 6 around that limiting concept that I just described. Article 7 talks about copyrights and licenses. In other words, what sort of intellectual property prepared by the architect and its consultants are you as the owner gonna have the rights to? Are you gonna own the copyright to their work, or are you just gonna have a license to use? There's room for lots and lots of extra language in here to protect project owners. Just to give you a very tip of the iceberg, as an example of many things we could do, we could beef up the definition of instruments of service. There could be a little bit more language around, the idea about the design not infringing on other people's copyrights or other intellectual property rights, possibly some additional language around infringement indemnity. There's room for you as the owner to decide, am I good with the license to use the architect's drawings that is assumed to be given to you in the standard language of the B101-2017, or do you want to go further? Do you want a broader license, or maybe even do you want copyright ownership of certain aspects of the design? There's language and custom edits that you may want to consider about whether or not the architect has the right to revoke their license or aspects of their grant of intellectual property to you in the event that there's a dispute, or if there's possibly some sort of a non-payment problem. So lots of room for a well-advised project owner to edit Article 7 of the B101-2017. Article 8 is entitled Claims and Disputes. There's definitely room to beef up this section a little bit. You could be a little bit clearer, for example, on the obligation of the design professional to continue to perform their services during the pendency and resolution of certain disputes. Now, a well-advised architect is going to push back against that, not necessarily striking that obligation entirely, but maybe qualifying it a little bit on you making payments to them with respect to aspects of their work that are not involved in the dispute. So there's push and pull that's possible there. It's a basic assumption of most AIA contract documents that architects and contractors are not going to be responsible for consequential damages. And consequential damages are the really high damages that you as the owner might incur if the project is late, or if there are a variety of follow-on consequences that would flow from the architect or the contractor not performing. You may want to take a look at this waiver of consequential damages in Article 8 of the B101 and ask yourself whether or not it's appropriate for you to be granting that waiver of consequential damages to the architect. I would just say as an aside, as a lawyer who represents tons of owners but also tons of architects, if I'm representing the architect on your deal and you want to delete that waiver of consequential damages, I'm coming back to you and I'm increasing my fee tenfold, because I think that most architects are going to quote their fee based upon the assumption that there will be no consequential damages that they're at risk of, because those are the kind of damages that could be greatly in excess of the direct damages that would flow from an error that they would make and need to be corrected just in the project. I mean, if they, screw up your casino and it can't open for a week and you lose $10 million of gambling revenue a day, that's $70 million of consequential damages. I don't think the architect's fee proposal is going to contemplate being on the hook for that stuff. So you got to think about whether you as the owner are willing to waive consequential damages. I think that there's a concept called step negotiation that is really nifty for resolving disputes that I like to include in all of my contracts, no matter who I'm representing. I've got other videos that you can check out on my website about step negotiation. I am an enormous fan of mediation, and I think that probably a bunch of you are rolling your eyes right now, because I'm aware that if you ask a lot of project owners and really a lot of architects about the virtues of mediation, you ask 5 of them, you're going to get 10 opinions. I happen to be somebody who thinks that mediation done the right way is just the best way to resolve construction project disputes. A bad mediation doesn't get a dispute resolved, but a good one does. And I like to joke that if I were going to get a tattoo on my body, it would say, "I love mediation." So if you're sitting there thinking that you dislike mediation, you're going to strike that obligation out of Article 8 of the B101 Claims and Disputes, let's talk about it. I would urge you to not do that because it's not in your interest. I think that another concept that you got to be careful of is choosing consistent dispute resolution clauses as the owner. You wouldn't want to have to litigate with the architect and then arbitrate with a contractor over a common problem. If you're going to litigate with a contractor, you should be selecting litigation with the architect and vice versa. There's also room for you to kind of put some language in here that might allow you to make a unilateral selection of whether you prefer arbitration or litigation. And it'll be your choice which one you pursue if there's a claim after the claim arose, because maybe you'd prefer one or the other, depending upon the nature of the claim. So lots to think about here, lots of ways that a construction attorney could beef up your Article 8 of the B101 to make it a little bit of a better document for you as the owner. Article 9 is all about termination of the contract or suspension of the work. There's room for you to beef up the language around the conditions where the architect can terminate. There's an alternate language that I like to include to sort of flesh out your rights as the owner to suspend the work or to terminate portions of the project. I like to be a little more explicit, actually much more explicit, about the architect's obligations upon termination of the contract, whether you're terminating them or they're terminating the contract. There are important concepts around you having the right to take over some of their consultant agreements so that you can keep working with their consultants. Some of this is in the B101-2017 already, but could be fleshed out. Article 10 of the B101-2017 is entitled Miscellaneous Provisions. And here is where I like to include a lot of my, secret sauce, a lot of the trade secrets. There's a bunch of stuff here that a well-advised owner is going to need to get in the document. You might need the ability to assign the contract to related entities to your, if you're a real estate developer, you may have a number of entities that you might have to assign the contract to, maybe to a purchaser, maybe to a lender. You might need to be clear about the obligation of the architect to execute certain certificates, maybe certificates or documents that your lender is going to insist upon. You might want to address the extent to which there might be third-party beneficiaries to this contract that would be able to enforce your rights against the architect. I think that there's room to give a little fuller treatment to the concept of hazardous materials in the B101-2017 Article 10, and specifically, the extent to which the architect is allowed to either specify or allow certain hazardous materials to be brought to the site. There's language to clarify its role as your protector, because as your quasi-representative on the site, there's a little bit of a gray area in terms of like the extent to which they can bind you. And so we want to be clear that they're an independent contractor, and even though they have certain rights to kind of act on your behalf and to help you by rejecting work if it's bad. And this is all sort of in the A201 general conditions and its overlap with the B101, notwithstanding the fact that the architect has certain rights and responsibilities to help and protect you. They can't bind you in certain ways, and they're not your partner. They're an independent contractor. So there's some additional words that could go into Article 10 about that. There's language that could be added about licensure and registration of the members of the design team in here. I think that one of the things that a well-advised owner is going to think hard about including somewhere in the B101-2017 is an indemnity clause, general indemnification. Here's where you're going to want to be careful not to spoil the architect's professional liability insurance by insisting that that go too far. And the indemnity clause should not contain the word defend, because the defense obligation is uninsurable. So a general indemnification clause in the event of design malpractice is a good idea for an owner. And if you wish to include an obligation for the architect also to defend you or to hold you harmless for certain types of risks that would never be covered by insurance anyway, like mechanics lien claims, for example, brought by their subconsultants, or certain other things that would never be insurable anyway, it's maybe not a bad idea for you to have two indemnity provisions, one that you keep clean and insurable for professional liability claims, and another one that maybe goes a little bit further and gets into some of these defense and hold harmless obligations in areas where the architect's insurance wouldn't respond anyway to the claim. So it doesn't matter whether you put some of those words in there. We could go further on Article 10 about what is force majeure, and when the architect would be entitled to more time or possibly even more money in the event of delays. Article 11 of the B101-2017 gets into compensation, specifically your payments to the architect. The requirements for progress payments might not be the same requirements for final payments. I mean, as your attorney, if I represent you as the owner, I'm looking at your loan documents and your escrow agreements, and I'm looking at state law, and I'm thinking hard about, is there a difference between a progress payment and a final payment in terms of what I need? I'm probably going to be, interested in some language in Article 11 that would give me the right to withhold dollars from the architect in the event that I think that there's a claim against them. But I want to be really careful here to not screw their insurance up, to not void their professional liability insurance by essentially writing a clause which says that if I think they're negligent, I get to not pay them, because that's the kind of thing that's going to screw their insurance up. If they're negligent, your remedy as the owner is to make a claim against them, not to not pay them. And you wouldn't want to put those words explicitly in the agreement. That doesn't mean that you can't get closer to that concept around not paying them if there are certain types of claims that you face as the owner that their insurance would never help them with. So you don't have to worry about voiding the insurance. But, Article 11 compensation, the extent to which when you pay, when you can withhold, and you really want to be careful not to blow that insurance up, because withholding for negligence claims will do that. So you got to be careful here. There's other language that could be, included in here about your right to make a partial payment, right? And making a partial payment to an architect in the event of certain contingencies is not the same thing as saying that, like, I'm not going to pay you because you're negligent. So we really have a lot of fine distinctions that we make in here, where a well-advised owner can get everything they need without screwing up the architect's insurance, but still have certain withholding or partial payment rights. This is where that back and forth between somebody like myself and your insurance broker to make sure that we dial in these just so that insurance responds the way it should is very important. And so, in conclusion, I have not covered even 1,000th of what I think about when I negotiate the B101-2017 on behalf of my owner clients. These are very deep waters that we're swimming in, but I think it's an excellent document. And I don't think I have ever had the instinct that where an owner would come to me and say, I want to use the B101-2017 to hire the architect, and I've said, bad idea. It's a great document. It's the flagship AIA owner-architect agreement. It's flexible. It's logical. It's ready for sensible customization. It pairs nicely with the 8-to-1 general conditions. It preserves the important concept of the architect protecting you from certain construction problems in the construction phase. And as long as you, as a well-advised project owner, are able to spot project-specific issues, party-specific issues, state law-specific issues, requirements of your loan documents, requirements of your lenders, requirements of your tenants, requirements of your escrow agreements, as long as you're able to think about how to flesh out the scope of the architect's services in a way that is sensible, that trains their attention to your expectations around the issues we've discussed today, and you're able to walk that line between swinging the document a little bit more in your favor without going outside the bounds of commercial reasonableness, without upsetting the architect's commercial expectations, and without screwing up their insurance, I think that you can have excellent project outcomes hiring architects with the B101-2017. You can have good design work for a fair price. You can have win-win outcomes. You can have projects delivered on time and on budget without disputes, so that everybody can be happy and they can roll on to their next project and continue to work together, continue to be friends, and possibly deploy this excellent contract document, AIA document B101-2017, the owner-architect agreement, on your next project as well.